honestly just
Are you
every
reading
aspect
something?
of it. Yes.
Oh, what are you reading from?
An email that I have
Oh,
from.
can I have it?
Yes.
Can you read from there?
From here?
From up the, no, I meant it was so far away from this.
This is the plaintiff, Kelsey Dubois. She says she developed a card game for kids, and the defendant signed a deal with her to sell the games, and he owes her money, which he refuses to pay. She's been working on this game since she was a child. The defendant's trying to squash her dreams, and she's here in the name of justice, seeking the $500 she's contractually owed. This is the defendant. He says he signed a deal with the plaintiff stating he had 2 years to produce and sell her card game. Unfortunately, there wasn't a big appetite for a recipe-themed game. The art wasn't appealing, and the game wasn't playable. Well, he doesn't owe the plaintiff $500, and this case will soon be game over. He's accused of being a card shark.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Millian in our forum, the People's Court.
Be seated, come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome, ma'am.
Kelsey Dubois?
Yes.
Okay, is that how I pronounce it?
Yes.
Okay, well, that's how I pronounce it. Is that how you pronounce it? You're suing the defendant in a personal capacity as well as 2 of his businesses that you say are liable to you because they breached a contract to develop a game.
Yes.
Okay, tell me about this game.
It's a children's game called the Recipe Game.
Okay.
It has different recipes and recipe cards. So the goal is...
Is that the game?
Yes.
Okay, bring that right on up here and show me what you got.
Order for me, please. Thank you.
Okay, so this is the game. These are the recipe cards. So there's just different recipes, and then there's ingredient cards that you are to collect. Of each
Oh, and then
recipe.
this is 1 egg, 3 cups of flour, so you try to get the right amount to be able to complete a recipe.
Yes.
That's pretty cool, actually. It sounded kind of goofy when I read it in the complaint. I'm like, everybody wants to create a game, but this is actually clever. Okay, so how long had you been trying to market it? Here, you can take it, actually. Actually, leave that here with me. Okay. You go ahead and go back there. I'll give it back to you at the end.
Well?
Yeah, that's fine. Yeah. All right, so how long had you been developing that game?
Well, I actually created it when I was like a child. Me and my sister were just making games one day, and I came up with this one, and I actually drew all of the pictures by hand. And then about 3.5-ish years ago or so, I actually wanted to make it into like an actual game that is marketable.
Okay.
So pretty much since I was like 8, I guess.
Okay, so you weren't you didn't find anybody interested in it until he came along.
Right. Well, I just did it on my own. Like I had it manufactured from China and had it imported and got all of the graphics made. I hired a graphics designer who actually did graphics. It was like
So
a
how did
whole-
he find you? Did you find him or did he find
No,
you?
He found me on. So my page was actually like I didn't even know that it was still live. And then he reached out to me saying that he found it on and thought that we would be a good partner.
Okay, so what do you do for a living?
So we create content internally. I started the company with my girlfriend and my best friend from college in 2015.
What does create content internally mean?
So I'm a writer, and I work with a co-writer, and my girlfriend's an artist. So we started creating content, comics, books, stuffed animals, for about 2 years. Then we decided to branch out into licensing and acquiring content that we saw had potential.
Meaning, how many games have you marketed?
I'd say about that we have produced over 35. And
What are they? Anything I'd know?
I don't know if you'd know them.
Do you sell them?
They're on Amazon.
They're on Amazon.
Yeah.
That's what I was going to ask you. Who sells them? Just Amazon or anybody else?
So we sell to distributors, some mom and pop shops, and
Okay. So you find her through...
so me not personally. We have a team of people at the time, our editor-in-chief, would scout for concepts that he thought had potential.
Okay, so tell me about it. Who do you hear from? Their editor-in-chief, and what does he tell you?
That they said, wow, we've been sourcing the internet for some great games to partner up with, and this caught our eye immediately. We loved your campaign, and honestly, just
Are you
every
reading
aspect
something?
of it. Yes.
Oh, what are you reading from?
An email that I have
Oh,
from.
can I have it?
Yes.
Can you read from there?
From here?
From up the, no, I meant it was so far away from you. Hand me that.
Ma'am, I got
That explains what, I'm sorry, I handed it to my bailiff. That explains why you've given me a contract that's in like 4-point font.
Sorry.
We would be covering 100% of the manufacturing and other associated costs, no risk or liability for you. I hope we make a deal soon, blah, blah. So do you contact him?
Yes.
And they send you a contract that they'd like you to sign. Mm-hmm. And it's basically the agreement between the two parties. It says what the percentage split is going to be, right?
Yeah.
And in your mind, how long was this contract to be for?
Forever, I guess.
Yeah. Someone actually inserted the words in perpetuity in there. Now, let me ask you, what have you done? Have you had any success? What have you done?
Me, Your Honor?
Yeah, that's you.
So over the past couple of years, after we signed her in May of 2017, we started to look at editorial to make it more accessible and playable to people that haven't seen, such as inserting diagrams, quick start guides. So in that time, the edits had not been made, but we were still pursuing other options, and we inserted.
Was anybody interested?
No.
Okay, let me ask you a question. Sometime in May, you say, hey, where's my $500? There's a clause in the contract that says that within 2 years you will pay me $500. Who do you say that to? Why isn't she entitled to the $500?
I actually believe that she is entitled to the $500. The dispute, I believe, arose that, from our understanding, she would like to have the $500 and her rights back. And what we had told Kelsey was that she can have either the game back and we can unilaterally terminate the contract and there would be no $500 owed, or we can give her the $500, we keep the rights, and we continue doing what we're doing.
What happened? She started to market, your editor apparently left your employ?
He did. Our former editor-in-chief decided to part ways with the company and start his own business. And he had reached out to Kelsey. And that is kind of, I believe, when the relationship started to build a tension, because we felt that Kelsey was in breach of selling the game to another publisher.
Wait, she'd have to have tried to sell the game to the other publisher. Talking to him doesn't
And
create a breach, so what was the problem?
She did sell it to him, and we have the picture evidence.
She sold it to him when?
July 15th, 2018.
Let me see what you're talking about. What happened in July?
He did reach out to me, in which case I was like, well, I have 300 copies. So he told me that I was free to do with those whatever I wanted.
Is that in the contract that you're free to do with it?
No, he just had told me that before, because I told him I didn't want to sign the contract, that there was a few things that were kind of
Okay, I'm sorry, you did sign a contract. Did you ever put in the contract that the 300 games you had, you could just sell?
No.
Did you ever agree to that?
Never. I would have never agreed to that, to have two products in a marketplace at the same time.
Yeah, I mean, that's a problem, and it does, your contract does state that you're not going to do something that would hamper, them being able to market your game, and selling your 300 copies doesn't sound like the kind of thing that guy would agree to.
True.
It just doesn't. But now, she was asking for the $500, and that rubbed you the wrong way. Why?
Welcome back to the People's Court. Harvey Levin here. Do kids, I don't know the answer to this, do kids like card games?
I'd say so. Depends on the card game.
What do you say?
I think yes. It depends on the kids too, but yes, some card games are for kids.
I'm looking for a kid around here, and I don't see a kid, so I'm going to have to go to you.
I would say they do play card games. I think a bunch of new games are coming out, and card games are still there.
Really? Because I thought it was all high-tech stuff. I was about to say another word than stuff. Oops. Yeah, that's what I thought. Okay, going inside the courtroom.
There were a few things that were happening. So we had offered in the email to give the rights back to her if she would like them back. Or we can give her the $500 and keep the rights. From our perspective, it seemed that she had wanted both. And at the time...
That's not really what your email says. What your email says is, We wish to resolve this amicably. It seems we are at a standstill. We feel you were in breach of your agreement with us by selling inventory and competing with us with our former editor-in-chief, which we own the rights to. If you would like to terminate the agreement, let me know. We can just part ways, which is what it feels like you want. However, at least let's please take a step back and talk reality instead of confrontationally. No lawyer in their right mind is going to waste time in a game that made less than $200 when there is no dispute. Well, that was kind of mean. We aren't afraid of attorneys, Kelsey. I work with them every day. No need to come in with a grenade just because a relationship isn't working out. Thank you so much.
Yes.
All right, so now she responds to you. Thank you for your prompt reply. My aim was not to be confrontational. As far as a breach in the contract goes on my part, I have forwarded you an email you had previously sent me stating that I am free to... Oh, you have an email where he says you're free to sell it?
Yes.
May I see that?
Yes.
I didn't know you had it in writing.
Yes.
Thus, I believed I acted in good faith. I don't want to get another party involved, but it does state in the contract that by May 4th, you should have paid a minimum of $500 to me, so this amount at least is within my rights. Oh, there it is, May 4th, 2017. We can only purchase them on consignment. We can't guarantee we can sell those units without our logos on them. You're free to sell those as you wish once we sign. Would you like to see that?
Yes, I would.
Yeah. Maybe it wasn't from you, maybe it was from your representative?
Yeah, so I have 2 emails, and then I have another email marked
Okay, I don't know. Okay, listen. It's a guy who works for you. It's you.
Okay.
Because these are all your emails you have access to. So that's, and this binds you, obviously, but I also think you knew it. Now, the next, because it's really a chicken and an egg thing, isn't it? You're saying she's breaching by marketing the game. Well, it turns out she's not. She's saying you're breaching by not paying her the $500. You know, there's this breakdown where your response is, yeah, we're going to be terminating. There won't be any money due. If we paid you the $500, we'd be keeping the rights, which you clearly want back. If you want to get another party involved for $500, I can tell you on principle alone, I'd just pay thousands to not give you $1, if that's your motivation. We can part ways amicably, or we can fight for fun and pay lawyers. Your call.
Yes.
Let me ask you a question. Did you read the attached email where you had given her permission to sell those?
There was no attached email that I saw that day.
But it's attached to this email. She's printed it out. Plus, I showed it to you, and you know you sent it. And she refers to it in the May 22nd email that she sends you. She says, I've attached the email. Plus, it's in your computer. So why such a hostile response? Just because she sold it to your competitor who left your firm? Or it seems, it doesn't seem particularly well thought out if, in fact, there's a future for the game. I understand what you're saying. Look, the contract, what it says is this, and so he's right when he says this. The contract says that you're entitled to $500, and I'm entitled to the rights in perpetuity. But if you want to end it, you need my agreement to end it. That's how this contract reads. She gets to say, I'll take the $500 and you keep the rights in perpetuity. And that's not how you sent the email. You sent the email saying, we're terminating. You fired her. You put the cart before the horse. Was there any communication after that?
No.
Right. So who breached? You don't get the right to terminate unless she agrees you terminate. You see? You do have the right to say, if you want your rights back, I will give you your rights back, but it's going to cost you. It's going to cost you, and you need to agree with me that then we don't have to pay you the $500. But what you don't get to do is terminate and not pay her the $500.
I agree.
And that's what you did.
I agree with you 100%.
Right. So you breached. You terminated in this email, and you didn't pay her the $500. Right? Did he ever pay you the $500? No. And he terminates you, and there's no other communication since May.
Correct.
You know that's not how the contract reads. You breached. She gets the $500. Verdict for the plaintiff, $500.
So the judge finds for the plaintiff she is going to get the $500 she was seeking. Are you sorry you couldn't sell the game? Did you really try hard?
No, we did. And I thought that the concept is cool. Everyone likes cooking. Everyone likes recipes.
Yeah, the judge liked it.
It's a cool concept. It's just sometimes it's hard. The market's very oversaturated. We see a million games out there.
Okay, very good. Well, thank you very
you
much.
so much.
Good luck to you. Thank you. Ms. Dubois, you kind of came out on top. I think the judge liked the game.
I think so.
You still going to push it? Try to do
I'll
what
try.
you can?
Yes, I will.
Don't give up.
I know.
You know?
I've been working on it for this long.
Yeah, gosh,
so,
don't give up at all.
yes.
All right, good luck to you.
Thank you so much.
Okay, thank you.
Thank you.
You know, they were talking in this case, Doug, about adding things once the contract is signed. When you add to a contract, get it in writing, especially if the original deal was in writing. That'll do it for this case. Litigants for the next case on the way into the courtroom right now.
This is the plaintiff, Albert Shimon. He says he went to the defendant's place of business to purchase a commercial mixer for a bakery, and the guy sold him a dud machine. He wasted $600 trying to repair it, couldn't, and is now seeking the return of his money. This is the defendant, Albert Katayev. He says the plaintiff brought his own technician in to repair the mixer, and for some reason the guy never fixed it. The plaintiff never gave him $600 to repair the mixer. He gave it to the technician. So how's the plaintiff coming after him for the money today? He's accused of cooking up a lawsuit.
All parties, please use your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff bought a commercial mixer for his bakery from the defendant, and it was a stinker. It didn't work. But the defendant says the plaintiff's going after the wrong guy. It's the case of Mixer. He hardly knew her.
Thank you, Doug.
You're welcome.
Okay, so you were going to you were the landlord renting to a bakery that was going to open up on your premises.
Correct.
And you were supposed to supply a mixer to the bakery?
A mixer.
Okay, and now what kind of mixer are we talking about? We're not
It's a
talking about the
dough
one in my
mixer.
house.
To mix, yeah.
Yeah.
It's a big dough mixer, 200-pound dough mixer.
Okay. And so how did you find the defendant?
He's down the block from where we are.
And he sells what?
Used equipment.
Okay, so had you bought things from him before?
No.
All right, but he was geographically desirable. So you
Yeah.
walk over and what happens?
Walked over, found the mixer. It's a large mixer. It looks very old, but he said it works very well. Everything works in it. I said, fine. We agreed on $2,500.
Did you turn it on to see if it worked?
No.
Why not?
I had to bring a mechanic to do that.
Why did you have to bring a mechanic?
Because I have no knowledge about equipment. I have no idea what I'm buying even.
Okay, I'm sorry. Did the thing work?
That mixer was purchased maybe 3-4 years ago, and it was standing in my showroom.
Okay.
And
So is there a way to turn it on to see if it turns on?
yes,
Okay, did you turn it on for him?
I tried to turn it on. It did not came on.
Okay, now hold on.
Yes.
Is that accurate?
He never put it on until the mechanic came in. I said, I have no idea what I'm buying. Put it to work in front of me, in front of the mechanics.
And so you bring a mechanic and what happens?
He said, okay, let's plug it in. See if
And
it
then what
works.
happens?
Nothing works, only one light.
And then what happens?
He says, let me check it out for a few minutes. He opened it up. He says,
He being the
all
mechanic.
Mechanic.
Okay.
All the wiring are corroded, falling apart in the machine. There is no way to start this. I'm going to have to rewire this completely first to see if it works.
Okay.
He was in front of us. We agreed on $600.
Who's we?
Me, the mechanic, and him.
Him. What does he have to do with your mechanic getting paid to inspect something to see if you want to buy it?
Not to inspect. I told him, if you want me to purchase this, we have to fix this. Otherwise, this is a dud. It doesn't work.
So,
I say, if not, I'm going to walk away. I don't want it.
right. So what was the price you guys had negotiated beforehand?
$2,500.
Okay. So then the mechanic was going to charge $600 to fix it.
To rewire it, to put it to work.
To fix it.
To rewire it, yeah.
To fix it.
Supposedly fixing it.
Okay. And then, so he was going to you were part of the agreement because
100%.
you were going to take $1,900 for the thing.
Exactly.
Okay. And then what happens?
Then what happened? The mechanic did his job, rewired the whole machine, plugging it in, nothing works. When he found out all the switches on the panel are no good, all has to be ordered from the manufacturers, and the motor itself, no good no longer. It's very, very, very old.
Okay. And so he never got $600, but your position is that was essentially a $600 deposit.
Correct.
Because he was assuming the whole cost of the repair and was deducting it from the purchase price. Did anybody foresee what might happen if that 600 didn't solve it?
Of course. Of course. That's why he put it in writing.
Let me see what you've got in writing.
Yeah.
Whose handwriting is this?
Mine.
Okay, I'm gonna need you to come up here.
Do you want the original one?
No, I'm still not gonna understand your handwriting. So I want you to stand right here and read that to me. One used, 2-bag mixer, 200 pounds.
Yes.
Payment for what?
For repair.
For repair.
$600.
600.
On the bottom.
Model, whatever, and then what's that say?
I asked the technician name because he has...
Jose?
Yes.
What's that say?
Warranty, he want to provide 1-year warranty for his repair. And I put on the bottom, it's a customer contractor.
That says contractor?
Yeah, company. I'm sorry.
Customer company.
Yes,
30 days for motor by...
by me, by
That's
my
you.
company, yes.
His position is that by doing this, if you have a beef, go sue Jose, even though he's the guy who brought Jose in, because you adopted Jose as being able to fix this. And it's very clear from this, he says, that he was only going to buy a working mixer. Can you go ahead and go back there? Yes, I know he brings Jose.
Yes.
But the three of you worked out a deal where I don't think anybody thought Jose couldn't fix it. Everybody thought Jose's going to be able to fix it. Everybody's going to be happy. Who actually paid Jose? You did?
Yep.
Do you have proof you paid Jose?
Cash. It was cash. I went to the bank, took a $600 cash, and gave it to him.
Well, that had to have happened, though, because that was the agreement you guys had. Did Jose fix it and at your place in front of you, or try to fix it?
He tried to fix, he brought only one contactor, which cost $30, installed it, and he said, I need the other part on-off switch, which I'll come back on next Sunday. And he never did.
Okay, so, but we have a problem. And the problem is that you got involved in this deal. You got very involved in it by absorbing the cost of Jose and reducing your price by Jose, and then giving this guy a 30-day warranty on the motor, which implies that you know that if it's not a working motor, then he's not supposed to be out anything. Like, in other words, this isn't an as-is sale. You're giving him a 30-day warranty. And so after Jose couldn't fix it, did you hire somebody else who wouldn't bring a $30 part?
I am a technician myself.
So did you try to fix it?
The problem was because when you move the mixer, you have to remove the ball. It's a big, huge ball.
Did you try to fix it, yes or no?
Yes, it was.
Did you fix it, yes or no?
Yes.
You were able to fix it?
Yes, ma'am.
So it's working now?
Yes.
Okay, who's the fellow with you?
This is my son.
Okay.
Hi, Your Honor.
Hi. And what did he just hand you?
He had me the...
He also smells like a lawyer. Is he a lawyer?
Yes.
Yeah, there we go.
It's an honor, Your Honor.
Ain't even that big.
You see that stainless steel ball?
Yeah.
To go through the door, which is mostly businesses have 36-inch door, we must remove the ball out.
Right.
And when I bring it to my store, I did not bolt it together. I did not put the hook. This is why mixers have protection for safety, and we have a micro switch on that.
Right.
After it's happened, I had the other customer. He came in and he was interested on that. So I stick my nose and I find out that micro switch for protection was open.
Why didn't you stick your nose in it when he was around and before the other guy and before you took 600 off?
I have two reasons, because I was busy with the other job. I didn't have time. This is why I give him, original price was $3,500. This mixer's new cost over $16,000.
Right, but here's the problem, okay? I'm looking at the receipt you gave him, and it's very, very clear that you intended not to sell it as is. Hey, I gave you a good deal, tough, it's on you, like you're talking now. You intended to sell something with a warranty. That means you are agreeing this thing is gonna work. And then you agree to pay to make it work. When I say pay, to absorb the $600 in the deal in order to make it work, okay? And then it doesn't work. So here's a guy who has no mixer. You agree to absorb the price to make it work. And then he has no mixer. He's out $600. And I know you didn't actually get a deposit of $600 because instead of you getting it, he just went ahead and paid it to the guy, which you agreed for it to happen. But he's not supposed to pay it to the guy. You're supposed to pay it to the guy, according to this. So he did give you $600. He just gave it to the guy who you were going to absorb it from. You see? So, and now he doesn't have a mixer. And then it turns out it was a perfectly good mixer. Somebody just had to fix the switch. So did you end up selling it?
Yes.
What'd you sell it for?
$3,000.
Yeah, there you go. Okay. And now the guy wants his $600 back.
May I be heard, Your Honor?
You know, we don't allow lawyers to be heard in here, but I'm going to let you be heard, cowboy, as a witness and as his son. Go ahead.
So the plaintiff bought a mixer that didn't work. I suppose you could get it repaired. Does the plaintiff have a right to get money back just because it doesn't work and not get it repaired?
Yes, he should get his money back if it doesn't work.
How come?
He paid for a working mixer.
You do, but why can't you just get it repaired?
And you could, but if you paid for a working mixer, you should be able to get a working.
You could undo the deal. Okay. Ma'am?
But be reasonable. It's repaired once, I would wait. But if it's more than once, yeah, I want my money.
But you would give him a chance to repair it?
I would.
Fair enough. Going inside the courtroom.
I serve as Secretary, Treasurer, and General Counsel to the defendant. I review all the contracts, all the legal work, anything to do with the company. And what I want to tell you as a witness in this case is that generally speaking, when any used item is sold, as the company is a licensed used secondhand dealer by the New York City Department of Consumer Affairs, we fix whatever product it is, whatever product we sell on our own as part of the price. This gentleman, from what I understand, the plaintiff, did not want that to happen. He wanted to bring in his own mechanic.
Right. Then what'd your dad do?
When he asked for his mechanic to come in, he consented to that.
Your dad consented. What else did your dad do with this?
With the understanding that it is his responsibility to deal with him directly.
But that's not what your dad agreed to. Look at this form. Hold on a second.
Yes.
What your dad agreed to is that your dad would absorb the entire $600 to try to get it fixed. And two, way more importantly, it'll be successful because I'm giving you a 30-day warranty. He has a deadline. He's got a tenant moving in. And then your dad's answer to why he didn't fix it. Like, in other words, if your dad tinkered with it right after that guy and was able to get it in time to him, that'd be great. But when did your dad tinker and fix it? Later. And so how on earth then could your dad, A, sell him a work? We know that your dad agreed to sell him an operable machine. Not an as-is machine, an operable machine, right? Yes or no?
I respectfully disagree, Your Honor.
How on earth, when you say 30 days for motor,
I'll explain.
How is that not a warranty?
I'll explain.
Okay, you're not really a witness. You're a lawyer here, but go ahead.
The warranty is for the motor only. He testified that the wiring was the issue. And we had testimony about the contactor and the wiring.
I'm sorry. As it turns out, nothing was an issue. Your dad had disconnected something and forgot to connect it. But please tell me how it is when your dad is... Essentially what it is, yes, you guys fix it normally, and your dad made an exception in this case.
Correct.
Your dad decided that he would pay somebody to fix it. He would pay somebody to fix it. That's why it's deducted from the purchase price. Not he. See, I thought, before I saw this, I thought that guy spent $600 to get some guy to look at it, and then inappropriately was trying to get this guy to absorb it.
But that's exactly what's happening.
It isn't.
Because the original...
It isn't.
The original
because...
agreement...
Take a look at what your dad wrote before you got involved in the case. What he wrote was, I'm selling it to you for $2,500, but I'm gonna pay somebody. I'm gonna pay somebody $600 to fix it, and so I'm really just selling it to you for $1,900. Nobody thought that the guy couldn't fix it, and now that the guy couldn't fix it, what happens? He's right. That $600 is a deposit, and it goes back to him. But you're a good son and you tried hard, but you can't fix the stuff your dad does behind your back before talking to you about it. $600 verdict for the plaintiff.
Thank you, Your Honor.
Thank you.
Well, that was kind of fun, Mr. Katiev. You brought your son with you. He gave it the good college try. What do you think about it? What's your reaction to what the judge just said?
I disagree with the judge's decision. I thought that there was a modification of the agreement. The original agreement was for 25, and then he agreed to reduce it by 1,900.
Judge says you're wrong. Sorry, good try, lawyer. Okay.
Yeah, thank you.
You got to give him the $600 back.
Of course.
Okay, but anyway, you sold the machine for $3,000, so you're still okay.
Of course.
We're down
Good for
100.
you. You're down 100. Okay. Congratulations.
Thank you.
Well, not congratulations. You're the loser.
Thank you.
Okay, good luck. All right. And you are back where you were. Did you ever get a machine?
Oh, yeah.
Oh, you got one somewhere else.
4,500. Yep.
4,500. Paid more. But is it working?
Yep.
That's
100%.
100%. Congratulations.
Thank you very
Okay,
much.
thank you very much. You must sign some documents. Harvey?
Okay, even if there isn't a warranty, there is something in the law called a warranty of merchantability. And usually if somebody's in business selling products, the product has to perform the function for which it was made, intended. And if it doesn't, it violates that warranty. And those warranties are implied in every contract for a product. That will do it for this case. Litigants for the next case are on their way into the courtroom right now.
This is the plaintiff, Sierra Farrow. She says she rented an apartment in the defendant's garage, and the lady snooped on her when she had friends over and listened to her conversations. She got out of there lickety-split. Now the evil woman won't return her security deposit, so she's suing the eavesdropper here and now for the $1,400 she's owed. This is the defendant, Daphne Relaford. She says the plaintiff was a horrible tenant who ran the air conditioner full blast with the windows wide open. She also changed the locks without permission. She left early and she's keeping the woman's security deposit for all she's now out. She's accused of terminating a tenant.
All parties, please use your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff rented an apartment from the defendant and says the landlord was snooping on her, made her so uncomfortable she moved. Now she can't get her deposit back. But the defendant says the plaintiff was a horrible tenant who ran the AC at full blast. It's the case I was just eavesdropping in.
Thank you, Douglas. So you were living in a garage apartment, was it?
Yes.
All right, in Broward County,
Yes.
Florida? How long had you been living there?
Almost a year. I moved in December.
All right, when did the problem start?
In August.
And what was it that happened?
The air conditioner wasn't working when I came home from work.
Okay, so this is a a window unit air conditioning?
Right, but it's in the wall. It's not actually in the window.
Okay.
Yeah, it's in the wall.
And it wasn't working. How was it not working? Was it blowing air and it was hot, or it wasn't turning on?
It wasn't turning on at all.
Okay, did you contact her?
Yes.
And what
I contacted her after the third day because
Why
I figured
didn't you contact her the first day?
Because I figured something was going on. She was working on something because she does like the housework herself. So
wait. Did you contact her the first day to say the AC's broken?
Not the first day.
Why not?
Because I saw something open outside, like on the wall. So I figured she was working on the AC, which I did tell her that too. When I contacted her the third day, I said I thought she was working on something. So I didn't.
You're very patient. I wouldn't have been. It's Florida.
Yeah.
It's South
Yeah,
Florida in August. I know what that is. I live there. So all right. So on the third day, according to you, because see, a tenant would call. Like the first day a tenant calls is probably the day the AC is not working. I don't know whether you're trying to make it longer. There's something a little fishy there for me. But all right, you say you spend 2 days in Florida in August sleeping with no AC in a garage. So there's no air. And then you call her and say what?
I called her and I was saying, are you working on the AC? It's not working at all. And she basically tells me she doesn't know what to do. She's in New York. She doesn't have anyone to send. And so I tell her,
Is all this by text?
No, we're on the phone at this point. So I was telling her, I can't breathe and like something has to be done. And she just told me, well, I don't know what to do. That's all she told me.
All right. When she called you and told you there was something wrong with the AC, what did you tell her?
I told her I was in New York and I would not be back until Monday night.
Right, but what does that have to do with fixing a tenant's problem? That has zero to do with it.
Your Honor, it's a tiny unit. I do a lot of the work in my household for myself. I do not
I know it's cheaper for you to do it yourself.
Yes.
But that's different from whether it's legal and correct and you're abiding by your duties as a landlord. If somebody tells me I don't have AC and it's August in Florida, you got to call somebody and see what, you got to pay and see somebody and figure it out. When you come home, do you take a look at it and see what the problem was?
Exactly, I did.
And what was wrong with it?
Nothing was wrong with it. All I did was press the reset button and it was up and running. Nothing was wrong with it.
Well, why didn't you just tell her that on the phone 4 days
earlier?
earlier?
I did not know, Your Honor. I did not know what to do.
All right. So in any event, what happens later is really what the subject of this lawsuit is, which is you take it upon yourself to deduct $150 from the rent. Did you discuss that with her before you did that?
I tried to. I said, I'm going to need something off of next month's rent because this is not, this is uninhabitable. And she said, we'll see. So,
all right. And then you just decided how much and paid her less rent without you two discussing it, right? Because that's what offended her. And when you did that, you then tell her, get out, right?
Yes, something like that.
Right. Now, you are suing for $1,400 security deposit. I looked at your lease and it says there's a $700 security deposit.
No, that's not correct.
Okay, do you have a lease that says you gave $1,400?
No, I don't have the lease because when I moved.
Okay, you understand that other $7 was probably your first month's rent. That's usually how it is. I have your lease. It's $700. All right, in any event, is this a legal apartment?
It is a legal apartment.
Is it? Because it's a garage that you've converted into an apartment.
Yes, ma'am.
Can I see your paperwork on it?
I don't have the paperwork on hand.
So if a landlord, I don't know, is kind of creepy and is like snooping on conversations and whatnot, making the tenant uncomfortable, can the tenant break the lease and get the deposit back?
They can break the lease, but if there's a clause saying something about the deposit, I mean, legally, they won't be able to get it.
But legally, I mean, at a point, is the tenant forced out by creepiness?
Yeah, it's very creepy, but, legally, so he can do it. That's what I think, but, well, it's a very tricky situation, so.
I gotta ask you something. I'm sorry. I love your accent. Where are you from?
France.
That's I wouldn't have guessed that, but that's a really good accent. Am I allowed to say that? That's a good accent, going inside the courtroom.
Are you zoned 2-family or 1-family in that house?
It's a one-family apartment.
It's a
one-family house.
Stop. Is your property zoned 1-family or 2? Do you also live there?
Yes.
Right. So is your property zoned 1-family or 2-family?
1-family.
Well, then how are you able to rent that out at all, is my question, right? It's kind of on the sly that you're renting it, and yet you're trying to keep money for rent. Now, you actually had problems with her before the air conditioning, right?
Right.
What were your problems with her before that?
It was basically harassment. Like, one day I was cooking and I hear her yelling out to me, oh, Sierra's here. And I'm like, yes. And she's like, open the door, let the smell of the food out. And I'm like, why would I open the door while I'm cooking so flies can come in? That's one thing. And then, like, every so often she'll complain about the AC. Why are you running the AC when it's a cool day outside? And I'm saying to her, you don't know how you don't know how I feel in here. You're not in here with me, so you can't tell me if I'm hot or not. But even after I had that discussion, she kept fussing about it.
And according to you, she would snoop on you?
Right. It's like when I was having a conversation, like when I have company, you would hear the door open, like quietly, and then you don't hear anything. I have very good hearing, so if she was moving around, I would hear her. Like, you hear the door open, like, slowly and quietly, and then nothing else. Like, usually when
So what do you think she was doing? Just listening to you?
Yeah.
Were you doing that?
No, of course not, Your Honor. I could never do that.
Usually when she goes back there, when she does anything, she always makes noise. She slams the door when she walks out. She's, like, very noisy, so.
All right.
Yeah.
All right, here's the thing. When you own a house, you can have a roommate, that's fine. But when you convert a garage, which lots of people do to make some extra cash, you have to change the zoning in Florida to be a 2-family home, which you're never going to do with a garage. That's why nobody does it. So you are attempting to keep her security deposit essentially for rent. But here's what you cannot do. If you're gonna, on the sly convert a garage and collect rent and do it without the proper legal authority, you can't ask a legal authority to let you collect rent, you see? So you're gonna have to give her back the entire $700 because I don't even see how you have a legal right to rent that out. Yeah.
Can I also say that wasn't the only problem. There's like harassment with my visitors also.
Okay, is it enough for you to win? Because you're winning.
Yeah, I just wanted to say that.
Verdict for the plaintiff and the amount of the actual security deposit, which is $700. That's my judgment.
So the plaintiff will get her security deposit back. Ms. Ralliford, what are you thinking about what the judge, if you'll step over here, please, right here. Okay. What are you thinking about what the judge just told you?
Well, I did not know that I could not convert my garage and rent it as a legal place. I did not know that.
Do you have somebody living in there now?
No.
All right. Well, thank you very much. You lost. Sorry,
It's
but
okay.
you learned. You
Yes,
lost,
I
but you
by
learned.
listening. Yes,
okay.
sir.
And
Thank
that's
you
good.
very much. Okay, yes.
Okay, good enough.
Thank you.
You're welcome. All right, Ms. Farrow. Well, good for you. You stood up for your rights. What are you thinking right now?
I feel very good because like that was what I went through. Nobody else should go through, and I hope no one else moves into there. So I just feel good that I got my money back because it was what's right. So
Good for you. All right, congratulations. Thank you very much.
Have a good one.
Okie dokes. Harvey?
Okay, Doug, look, the landlord needs a certificate of occupancy to rent a place. If he doesn't have it, tenant can move out, get the deposit back. The lease was never valid in the first place.